Look, this is, my lord, the emphasis I would very respectfully give. The object and purpose was that it is open for each legislature, depending upon the period of time they are making the economic policies, can have freedom to lay down economic legislations. My lord, complete freedom in joints is given to the parliament. That's the intention. So, my lord, ultimately, it is left to the parliament. Therefore, a little, not vague, but elastic, I would, my lord, put it that way, which can take into consideration the circumstances, factors, global factors, local factors, etc. Now, my lord, I am on page 16. Your lordships need not turn to. What I've said is this. The question, my lords, are deciding is whether a private property can include can be included under Article 39. What I have said is that when 39 was there, right to property was a fundamental right under Article 31. 19(1)(f), my lord, I'm sorry.
Which page is this when you have prepared? Page
16. 16. PDF 16.
Yes.
So, my lord, 39B and Article 19(1)(f), that is right to hold and dispose of property, coexisted. Meaning thereby, 39 always intended even private property. And its deletion now as a fundamental right and it going as Article 300A further strengthens, Lord, that submission. The 39B encompasses not just government property. Otherwise, for constitution makers, my lord, there was no reason to say that all property owned and controlled by the government shall be used for general good. My lord, your lordships are aware, my lord, like which, my lord, we assisted your lordships on the ground of another article where you have to give a declaration that this act is enacted in pursuance to so and so. The same is with 39. The act stipulates, my lord, that we are exercising, the parliament is exercising powers under 39B or C as the case may be. My lord, I have just, my lord, given a table of several legislations where they have, the parliament has used and mentioned 39B. And, my lord, please see the fourth column, material resource, my lord, which is sought to be regulated or distributed, my lord, under 39B. My lord, I must add one thing. My lord, this declaration, the way in which, my lord, your lordships have seen, my lord, in other cases, my lord, of alcohol, industries, etc., is not mandatory in case of Article 39B. But even if an enactment is not mentioning 39B, the government can defend it on the ground that I seek protection of 39B and therefore 31. Yes, my lord.
It doesn't say industry, the control of which is declared by
is Parliament. Declared by the, because the constitution requires a declaration. Here the constitution doesn't require the declaration. Land, right to use water, Mysore Palace.
For example, a simple thing is the public distribution, where the farmers have to give levy sugar, the farmers have to part with some paddy to the state so that that is taken.
Distributed equally.
Public distribution under
public distribution, PDS. Yes, sir.
See, that is an example, clear, stark example, so close to the people.
I think the
rationing of food grains.
Learned attorney possibly wants to say something. If
no, I was only trying to say about the Anglo-French textiles.
What is that?
I appeared in that matter way back in 1984. And that was a textile mill which is lying close in Pondicherry for about 3 years. After this honorable court intervened, then the government set up a Pondicherry Textile Corporation. That's how it was taken over. And it was a private industry.
Oh.
Another case where there is a change in the mindset. 1976 Urban Land Ceiling Act came. And in 1999 it was repealed. That is during the times of 1999 post-liberalization.
Correct.
So 1976 and 1999, that is a stark example of how there is a evolving economic democracy in the country.
Depending upon several internal and external factors. And when I say external means global market, internal factor means the production decreasing or increasing, the demand being less or more, etc., etc.
All right.
It must be remembered that court had occasion to hold so by way of dealing with the argument that nationalization did not have a nexus with the word distribution. Lord, the argument was, I'll just paraphrase my submission, my lord. The argument of the other side was, that was more in the context of MAHDA, that preservation of buildings or preservation of natural resources can never be a part of Article 39B. My lord, which, my lord, I have dealt with saying that intergenerational equity is a concept accepted by our jurisprudence. We preserve many things for the next generation. That is, my lord, what we call intergenerational equity. I have already, my lord, respectfully said that the views of Justice Krishna Iyer may perhaps not be relevant, my lord, in the present context. I would put it that way, my lord, and I very respectfully, while respecting the judgment and the view, Lord, respectfully seek to disagree.
You or some of it?
The sum of them. Lord, it's no, not entirely. I have too small
contrary to your
to disagree with Justice Krishna Iyer in the entire. But Lord, it was otherwise also contextual. It was in the context of the private property involved in that case, but the discussion became very wide and over-encompassing, my lord, which may...
He said that we are not to be construed as having accepted this line of
Correct.
this line of
Correct.
analysis.
And that was in a concurring judgment.
Concurring.
All that was said.
And my lord, my respectful submission at the cost of repetition, it is not an obiter. It is a ratio decidendi. My lord, I would urge your lordships to bear three factors in mind when a judgment can be said to be obiter. A, whether the question decided arose for consideration. B, whether arguments were advanced by both the sides. And C, whether the court dealt with cursorily as a passing remark or while dealing with a specific submission made by the counsel.
We got the point that you are saying that it was also dealt with by Justice Paripurnan. What happened was, the question was whether if a tax is struck down or if the levy has been held to be illegal, whether there should be a refund. The court said that, look, the manufacturers have not, they've passed on the burden.
Yes,
They are pertinent, and therefore it will result in unjust enrichment. And therefore, on the one hand, if you say that, well, the manufacturers will be entitled to a refund, all these resources will go into the hands of the manufacturers and promote a concentration of wealth. On the other hand, these resources could be used by the state for the purpose of the common good. And therefore, they said Article 39.
Material resources for the community, stressing it from 39B. Now, my lord, what is not quoted, but I must bring to your lordship's notice, there is a minority view in Mafat Lal judgment, my lord. The general discussion, my lord, which happened, this is not my argument, my lord, just by way of, my lord, reference, that in Keshwanand Bharti judgment, who decides what and what is ultimately ratio for what proposition, my lord, is not a criticism or a discussion qua 31C. 31C, the bench is very clear. 8 honorable judges unequivocally, with reasons, uphold the validity. 42nd Amendment C. This is Section 4 of the Constitution Amendment Act. Correct, my lord? Please bear that in mind. Because my submission is going to be that this amending section has gone.
Yeah.
31C was never under challenge. And if the view propounded by them is accepted by the court, what will be the devastating consequence? I have given illustrations. Lord, for example, tomorrow, one word from the preamble is deleted by way of a constitutional amendment. That constitutional amendment is challenged, and your lordship set aside that amendment that you could not have deleted. Economic justice, for example. Would the entire preamble go? That's the argument, my lord. It sounds absurd, but it is that absurd, and I'll show that.
Language is now meaningless.
It becomes completely meaningless.
Yes.
And I have quoted that language, that now, if they are right, how 31C would read.
Meaningless totally.
It becomes meaningless.
No, Section 4, the amendment of Constitutional Amendment Act, Section 4. That Section 4 is inserted into the main section, Article 31C. It is inserted.
Substituted.
Yes. So it becomes part of Article 31C. It does not have an independent existence.
Correct.
Maybe by a constitutional amendment act, but ultimately it goes into the main Article 31C.
So now what was included now no longer exists.
Yes.
And what was there in law has to exist. Well, that is my respectful submission.
So according to you, once Section 4 of the 42nd Amendment is struck down, that necessarily results in the restoration of the position as it existed on the date of the adoption of that provision.
And one more thing, my lord, why to buttress my submission. Lord my Lord Justice DY Chandrachud upheld the validity of 31C. My Lord Justice DY Chandrachud authored the judgment of Vaman Rao, which challenged the original 31C. But simultaneously, the bench presided by my Lord Justice Chandrachud, who also happened to be authoring judgment in Minerva, I'll show that, was considering post-amendment 31C.
Yes.
So there were two matters simultaneously going on. Vaman Rao, 31C, as upheld by Keshwanand Bharti. Second, Minerva Mills, 31C, as amended by 42nd Amendment. Both judgments delivered by my Lord Justice DY Chandrachud. And therefore, my Lord, I'll show there is a clear intention of the court. Court is conscious that this is what will be the effect of our judgment. That what was upheld by Keshwanand Bharti now stands revived.
So according to you, Vaman Rao was dealing with the unamended 31.
Unamended 31.
That's your contention.
There is no dispute on that.
But did Vaman Rao deal with the unamended section 31C in respect of a period after
The amendment.
the striking down of the amended 31C?
Yes, Madam.
Or was it dealing with a period prior thereto?
No, after. And therefore it says that what will...
Prior.
No. Kindly have a look at it.
Anyway, but just think, bear it in mind. You can go in your own way and then
Judgment came
come back to
substantially.